And finally, we're honored to have Floyd Clarke with us today. Mr. Clarke is former director of the Federal Bureau of Investigation and testifying on behalf of Allied Security Holdings, the parent company of Allied Barton Security Services, where he holds a position on its board of managers. Mr. Clarke joined the FBI as a special agent in 1964, working in Birmingham, Boston, Philadelphia, and Kansas City. He progressed to being a supervisor, assistant special agent in charge, special agent in charge, assistant director, executive assistant director, and deputy director before finally being named acting director in 1993. He obtained both his BA and JD from the George Washington University. Director Clarke, nice to have you with us this morning as well.
Thank you, Chairman Andrews and Ranking Member Klein and the rest of the committee. It's a pleasure, and I appreciate the opportunity to appear before you today to offer some comments about H.R. 2703. And as you mentioned, I am a member of the Board of Managers of Allied Security Holdings, the parent company of Allied Barton Security. And previously, I spent 30 years in the FBI, leaving in January of 1994 as the acting director. So I approach this issue with the benefit of the perspective from both the FBI and the private sector. Allied Barton is the largest American-owned security services company. We have more than 52,000 security officers in over 100 offices, and we service approximately 3,500 clients across the United States. Let me begin, Mr. Chairman, by commending you for your commitment to this issue over the years, as Congress recognized in the legislation that you were instrumental in helping to pass in 2004, that there is a homeland security imperative for having professional, reliable, and responsible security officers for the protection of people, facilities, institutions, and ensuring that these officers are thoroughly screened and trained. In an effort to achieve this objective, Congress enacted the Private Security Officers Employment Act to allow private security officer companies to submit requests through the states to screen employees against the FBI's criminal history records. Unfortunately, for a variety of reasons, states have generally not exercised the authority that they have been given, and employers still cannot regularly screen prospective employees against the national database. And I want to again commend you, Mr. Chairman, for recognizing the need to strengthen this earlier legislation. Private security officers, as you've mentioned, provide a primary line of defense for much of our country, securing countless lives, tens of thousands of important facilities from coast to coast. The threat of additional terrorist acts requires the cooperation between the public and the private sectors. The private sector, as you mentioned, controls 85% of the critical infrastructure in this nation, and unless a terrorist target is a military or other secure government facility, the first responders most likely will be civilians. Those civilians will include private security guards. We want to do all that we reasonably can to ensure that the officers that we hire are trustworthy and not likely to commit criminal acts or aid or support terrorists. At a minimum, this requires that our company have a reliable and timely way of learning about any serious criminal history of our applicants. Congress directed the Attorney General to examine the issue related to non-law enforcement access to federal criminal history records, and the AG concluded that reliable criminal history background check cannot be accomplished without timely access to the records of the FBI. Without access to the federal records, the only records available to an employee are those in the states where the records are typically kept in the courthouse in each county. Since there's no practical way to check all 3,000 clerks of courts around the country for every employee, employers will usually only request a check in the counties in which the applicant says that they have recently lived or worked. This leaves the employer blind to any criminal history in states for which the applicant failed to disclose contacts. Congress acted in 2004 to provide employers access to that federal database. Unfortunately, in doing so, Congress required that the employers always go through the state identification bureaus in order to get that access. In other words, we must submit the employee information to the state bureau, which then decides whether to forward the request to the federal level. An employer in a state that cannot or chooses not to provide timely background check results that incorporate both a state and FBI data should be able to make requests for criminal history records to the FBI either directly or through an entity designated by the Attorney General. We strongly support this recommendation and applaud you, Mr. Chairman, for incorporating this provision in H.R. 2703. I understand that there may be concerns that this legislation bypasses states. As I read it, however, it clearly requires employers to go through the states in every instance where the states are willing and able to respond. The only instance in which employers can make a request other than through the state is where the state has chosen not to establish a mechanism for getting prompt federal records checks accomplished. We fully support efforts to get more states to adopt such mechanisms. However, that will take time during which we will continue to have a dangerous gap in the screening. H.R. 2703 does not preclude continuing efforts to work with the states and ensures that as those states come into compliance with the AG standards, employers will be required to go through them for the record checks. Our experience indicates that the protections afforded to employees under the Congress included in 2004 are appropriate, and that the legislation that is being suggested and offered here builds upon those and even strengthens those. And I'll be more than happy to answer any questions that you might have.